21 before the hour. This is America in the Morning. I'm John Trout. The Supreme Court yesterday struck down a New York gun law that places restrictions on carrying a concealed gun outside the home. We're speaking with attorney Andrew Lieb, a constitutional expert and New York lawyer. Where does this ruling go from here, Mr. Lieb?
Well, it's not just the state of New York. You see, it was 7 different states that weren't shall-issue states. And shall-issue states mean that there's a default rule that you are allowed to have concealed carry. You see, New York had a rule that went back to 1911 called the Sullivan Act, which said, hey, you can only have a gun outside of the home, obviously, after the Heller decision in 2010. You could only have a gun in concealed carry if you had a particularized risk of safety.
Yeah, but doesn't that fly in the face of the Second Amendment? Because we have the right to bear arms. Why would states be able to rule that you have to go through some rigmarole to show that you should have something more than just the Second Amendment?
John, I'm glad you brought that up, because up until this moment, from Heller in 2010, Justice Scalia's decision, all the way till today, we believe that states could make an argument and say, if you're promoting an important interest in the public, you're allowed to do it. But Justice Thomas, on his birthday, he said, no, that's no longer the rule. We just looked from the history and the context from when the amendment came around. And there's 2 amendments, not just the Second Amendment that we're talking about. The first one's the Second Amendment, which is from 1791, but the Second Amendment's from the federal government. The 14th Amendment applies it to the states, and that's from 1868. And Justice Thomas said, if you look to the history, there's only one reason to restrict guns. That's really what he said there. And he said there's one reason to restrict guns. What is that reason? If it's a specific sensitive place. And he gave 3 illustrations.
Okay.
One is like the assembly.
Sure.
The next is polling places. And the last one's courthouses. And he said, absent an analogy to one of those, people have a right to bear guns. That Second Amendment, just like you're saying.
Attorney Lieb, shouldn't folks who believe in the Constitution, maybe they don't like guns, maybe they don't think people should have guns, but shouldn't they at least celebrate a ruling from the court that doesn't involve advocacy or a bench ruling per se?
Well, I'm going to put it like this. It's a decision on how to interpret the Constitution. I would argue that all Supreme Court justices believe in the Constitution, but the question is, are you an originalist? Do you believe the text and context from when it was written is what interprets the Constitution? Or do you believe it's a living document that goes to our time? Right now, we have a 6-3 conservative majority, and this Thomas decision is much more than just guns. It's a staple that says constitutional interpretation is based on originalism.
What's going to happen in states that have similar laws like New York, where you have to go through some paperwork or additional explanation? Like, say you're a jewelry store owner in a state and you have to go through additional paperwork just to be able to carry a sidearm. Are we going to see those states dissolve their laws?
I don't know if they're going to be dissolved, but they're certainly unenforceable after today with respect to constitutional muster. You may have heard of trigger laws when we talk about abortion, which means it was a law before Roe v. Wade that comes back and springs back into power. Because when Roe was decided, those states didn't dissolve their laws that said you couldn't get an abortion. So the fact that they're on the books, they're just unenforceable on the books after today, now that Justice Thomas made his decision.
Eric Adams, the mayor of New York, here's what he had to say.
And we cannot allow New York to become the wild, wild west.
We cannot allow New York to become the wild, wild west. I think he's seeing everyone with, sidearms.
Yeah, so it's interesting because Justice Thomas took that head on. He said that New York made this argument that Manhattan was a sensitive place because it's so crowded. You see, the antithesis of the Wild West. And they said, you know what? You can't deal if it's crowded or sparsely populated. That doesn't make a place a sensitive place. And only a sensitive place can we restrict guns.
Andrew M. Lieb is attorney at Lieb at Law, liebetlaw.com, a practice that provides a wide range of legal services throughout the New York metro area. Thank you, Mr. Lieb.
Thank you so much.